All right, we are live. This is Matthew Newsom, the attorney for Surge Business Law. This is January 26th, and we are doing a lunchtime live stream where you can ask me anything. And I do like to collect questions in advance. So check me out on social media or YouTube to see a place where you can ask me questions. You are welcome to throw things in the chat. Not certain I'll be able to get to them. But thanks for all of the questions we had. It is an interesting mix. It's been very unusual to start the new year with so many business conflicts, and I think we see that reflected in the questions for today. A lot of people have submitted questions privately asking me not to share their name because there are conflicts going on. Not my favorite thing in the world to do. I like to help businesses stay out of conflict, to have healthy relationships with their employees, their vendors, their partners, and ideally that means we don't need to do negotiations, demand letters, lawsuits, that kind of stuff. But that's why I'm here, is to help people resolve problems that they can't do themselves. Let's jump in and start answering questions. First, and this is kind of a simple one, does sending a demand letter increase the chances of a lawsuit? And the answer is yes, absolutely. Of course, it increases the chances. If you send a demand letter, you usually say, I want this, and if you don't, I'm going to do this. And whatever it is you're going to do, if the other party doesn't respond, is going to have some weight to it. And oftentimes it says, I'm going to sue. So first of all, if you send a demand letter, you better be prepared to back up your demands. Now, I'll be frank, sometimes we do send demand letters where the demanding party doesn't want a lawsuit, in which case we still threaten a lawsuit, but we might steer the parties into something simpler like mediation, which is usually faster and cheaper. But sometimes the only way to move forward is a lawsuit. So yes, sending a demand letter increases your chances for a lawsuit by nature. Here's another question. If you face a lawsuit, is dissolving your business a viable way out in the United States? And this requester did mention other countries as possible places where this could be true. And I don't practice law in those countries. And so the laws can be quite different. Although I have found that US, Canada, India, Australia, New Zealand, and other common law countries tend to be pretty similar to the US, but US laws do vary. I mean, every country can have different laws. And so if you face a lawsuit, is dissolving your business a viable way out? And the answer is no, not really. Because what happens is when you shut down or dissolve your business, you need to take care of your liabilities. And so just because you cease operating doesn't mean that your liabilities simply go away. So oftentimes a business will liquidate their assets or sell off their assets with the hope of paying off all of their creditors and making everyone happy as part of the shutdown process. Sometimes that can't happen, or sometimes that doesn't make them happy. And so your business, even a shutdown one, could be dissolved. And also, too, you might find that the the suing party might sue the business owners. Whether or not that works is something that would be specific to each situation. But no, shutting down your business, dissolving your business does not cut off opportunities to be sued. Although, if there's no assets left, it does limit the ability for a suing party to get relief. This is a great question to ask your lawyer and to ask to share specific details about, because every situation when it comes to these kinds of conflicts is a little bit different. And so you're going to need to talk to a pro. If you are in Iowa or one of the states where Surge Law practices, I think you should call us and we can help you. Will directors be held personally liable if the business is dissolved? And by the way, this and the previous two questions are from the same person, and so you might see some pattern here. But directors of a business typically do not have personal liability for the actions that they take in their business in good faith. However, you can take legal action against directors if they breach one of their duties or if they are personally negligent. and that personal negligence depends on the kind of business a little bit. But for example, a doctor can be sued for professional malpractice, which is negligence. And so some business structures, some business owners, some directors can be personally liable in those situations. Likewise, here is an example of a situation where a director or other officer of the company can be personally liable, and that is the breach of a fiduciary duty, or a breach of any duty, a duty of loyalty, for example. So if you are one of the people in charge of the business, then you are responsible for making sure that you do not have a conflict. And that means, you can't usually be a director of two competing companies because that would be a conflict. You can't do the duty of loyalty of taking care of the responsibilities in your directorial role to one company when you also benefit by the direct competitor um, uh, succeeding. So there are some cases where directors can be personally liable, and also to owners, officers as well. But typically, if you have an LLC or a corporation and it has been formed and managed properly, the maximum liability that an owner, director, officer can face is whatever money they have invested in the business. So if you spend $50,000 starting a business and it fails, you're going to lose that $50,000, and that's it. However, we commonly see people do things that weakens the protection of that wall between their business risks and their personal assets. And that is called piercing the corporate veil. And that does happen oftentimes, again, when a leader of a company breaches a duty. That's a really good way to weaken the wall of protection. But normally, if you've done things right, then directors are not personally liable, even if the business is dissolved. Okay. I saw this on Facebook and I covered up some details, but we commonly see businesses um, offering themselves for sale. And so in this case, there is a restaurant in some city that I'm not going to mention, and the restaurant has gross revenue of $1.5 million, cash flow of $300,000, 30 employees. It was established in 2021. And for clarity, I'm reading this to you in January of 2024, so somewhere between 2 and 3 years ago. And the person asked, what is the fair value for this business? And this is an excellent question that I see pretty often. And there's a couple important details here. First of all, the business is less than 3 years old. Second of all, the business is in a restaurant. The business is a restaurant. Also, too, you see some money numbers here: $1.5 million in gross revenue and $300,000 in cash flow. Those numbers are kind of meaningless because gross revenue can be interpreted different ways. And this is one of the problems with valuations, is that different numbers can mean different things. Cash flow is $300,000. That means if we interpret the $1.5 million as gross receipts and the cash flow as a net profit, then that means that this restaurant is operating at a 20% net profit. And I think that that is highly suspicious. So I don't think that those numbers are proper, because typically restaurants that are 3 years old or younger are not putting 20% profit into the owner's pocket. Maybe the most recent year they did. And so I suspect this cash flow number is something else. Here's the situation with restaurants. Restaurants are very high risk businesses. And why are they risky? There's a couple things. First of all, restaurants, you have to put a lot of money into the business just to open your doors. And so a smaller restaurant that is able to keep their costs low could easily spend $250,000 just to launch. And this is in the Des Moines metro area, which does not have a very high cost of living like some cities do. So you can do cheaper in a small town probably, but in a metro area, $250,000 is nothing to open a restaurant, because you have to buy equipment, you have to furnish the inside, you have to buy menus, you have to buy all of the ingredients and stuff to stock your shelves the first time. You've got to do marketing, you've got to decorate and things like that. So you really do have a lot of upfront costs with a restaurant. But then you have the psychology, and that is that some people, a small number, love to try the new place in town. And so if you're the brand new restaurant, you'll get some people in just because they want to try something new. But generally speaking, we find that people are hesitant to go to restaurants for a while. This is why Groupon was so popular back in the day, was because restaurants would use Groupon as a way to get people to try them for the first time. Getting new customers to walk in the door and try something for the first time is hard. And so restaurants would offer Groupons that would basically give people half off. The restaurant owner would usually make no money on those opportunities because Groupon would take the rest. But it was still a good deal because once people get their foot in the door the first time, they're more likely to come back if they have a good experience. Well, why does this matter here? So if a restaurant is 2 or 3 years old, they're probably watching all of their money go down, 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 down because the restaurant hasn't taken off. And we commonly see restaurants take off, if ever, and sometimes it's never, but if they do take off, usually around 3 year mark. And so it takes about 3 years. But during year 0, 1, and 2, the restaurant owner is shelling out cash, shelling out cash, shelling out cash. And finally, they just run out and they can't do it anymore. So what happens is when a restaurant is 3 years old and they're not making it, they get into a situation where now they've got a lease, and if they want out, they're going to have to spend money on exiting their lease. They might have to spend 30 grand. They probably have a loan, and so they've got all of this equipment. Maybe they spent $250,000 of it on it, but realistically speaking, the fair market value is $120,000, and the auction value is $60,000. And so if they want out, they're going to have to pay off their loan. Maybe they have a $200,000 outstanding balance and they got $120,000 worth of equipment. But if they're going to do fire sale, they're really only going to get 60K. And so now they've got $140,000 that they're on the hook for with the loan. $30,000 are on the hook for the landlord. And so you've got a business that is, its value is quite negative. And so a business owner who might want to turn the restaurant around, or maybe they have the cash to see it through to finally, get that success, they can usually get a bargain. And so this is an opportunity where if you watch one of my last videos where I talked about the different roles of entrepreneurs, or if you looked at the webinar on my website and you looked at what it's like to sell your business, one of the roles is the vulture. And so restaurants in particular, or businesses with high startup costs in particular, they're typically going to be looking at selling to a vulture. These people are going to come in and buy at a greatly discounted rate. But these still tend to be win-win situations, because if the restaurant owner is looking at spending $190,000 just to close their doors, which usually means filing for bankruptcy, or they have an investor that will come in and give them $60,000 cash. Well, that's a difference of like 250 grand. And so getting any number, any value is usually far better than shutting the doors and walking away. So these types of situations tend to be a bargain for the buyers. So if you have a passion for the restaurant business, you can keep your eyes open and look for a business that has potential, maybe a good location, maybe a good number of reviews, but they don't have traction yet. You can probably buy a business like this at a bargain rate. All right, so let's do the next one. What to do if someone is publicly lying about your business to get money? And this happens in a couple different ways. Sometimes we see people do negative reviews. They report you to the Better Business Bureau. Maybe they report you to the Attorney General's office. Oftentimes they want a refund or some kind of other financial gain, and they are willing to be dishonest in order to twist your arm. And so, yes, this is typically extortion, but legally speaking, what we're going to be talking about here is an area of law that is very common. That is defamation. Defamation is when somebody says or writes something negative about your business or you personally, and it causes you harm. So this is literally what we're talking about. If somebody leaves you a negative review and it is dishonest, and the purpose of the review is to give you harm, then you want to collect evidence. So if they text you, if they email you, if they call you, say, hey, you know what? You email me what your proposal is. Get it in writing. because then you've got the opportunity to use this evidence to sue for defamation. It would be amazing if you could get something in writing saying, yeah, I know this isn't true, but this is what it's going to take for me to get a refund or get money from you. You've got a great case. Typically, defamation cases are very, very hard to prove because people do in America do have a right to free speech, and we're going to get to that in the next question. People do have a right to free speech. That does not mean they have a right to lie and cause other people harm. That is not one of the rights in America. But the courts are very careful about squashing free speech. And so if they're expressing an opinion, for example, this business is the worst, right? Well, that is going to be an opinion. You're not going to be able to get defamation for it, unless you've got some really good evidence to help you out. But if someone is publicly lying and you can prove it, then you might be able to sue for defamation. One of the hard things for businesses to prove or people to prove in defamation cases is, have they actually suffered harm? If they have not, if you can't prove that you suffered actual harm, then you're never going to be able to prove this case. You need it. And so if you have people say, someone posts on social media and they say, oh, I'm never going to that business again, or something like that, screenshot it, because that's proof of harm. And so that gives you strength when it comes to getting a case of defamation. But I will tell you this, when someone calls my office and says, I want to sue somebody for defamation, I am very, very skeptical. And so be prepared that you're going to have to show that your case is different. But a lot of times people say, well, they hurt my feelings, I want to sue for defamation. That won't win. Or they said something bad about me. I don't think their opinion is valid. That's not going to do it. Or yeah, they lied and their mom believes them. Well, that's not going to do it. You need to actually show some kind of harm, and financial harm is really the best kind of harm to show. So what do? Get as much evidence that you can in writing, screenshots, whatever, and then you talk to an attorney. Does freedom of speech protect lies? And this is a far more complicated question than it sounds like. There's a singer named Kacey Musgrave, and she writes a song that I love to quote. And in that song, she says, everyone's got a right to be wrong. And that is true. So what is a lie? What is a lie? If a lie is defamation, then freedom of speech does not protect that usually. Now, some people have higher ability to be protected than others. So, for example, news organizations have extra protection. Politicians, especially if they're speaking on the Senate floor or House floor, if they're in their legislative session, have pretty much unlimited power to say whatever they want, including laws, without repercussions. People can express opinions that are wrong. That's fine. People are allowed to be wrong. And thankfully true, right? Otherwise, the world might not be as good of a place. But when these lies are intended to cause financial harm to someone else, then no, the law doesn't protect them. That would be defamation, and that's a good time to talk to a lawyer. But see the answer to my previous question where I talked about how hard it is to prove defamation and what you need. How does a small business protect against defamation? And to the person who submitted this question, yes, I know this is a greatly edited version of your question. You included details that I didn't feel comfortable sharing because you specifically asked not to be disclosed individually, and I respect that. I didn't think I could share your question as is without possibly pointing you out. So how does a small business protect against defamation? The first of all is that you really can't give yourself 100% protection, because the fact is people are going to say what they're going to say. Taylor Swift famously said, haters going to hate, right? And so you can't make everyone happy, and please don't try. Please don't try. I don't like the way that language in America now has got to be so sensitive. Oh, we can't hurt anyone's feelings. No, be yourself. Speak the truth. Do it lovingly. That's definitely some wisdom that's been shared from ages past. But be truthful, be honest, have an opinion, share your opinion in a friendly and loving way as possible. But you can also protect against defamation in a business setting by, first of all, working hard to have good customer service. And I had a client in yesterday who was suffering severe financial struggles because they entered into a business contract and the other party was not honoring the contract, and they kept trying to change it. And so what you need to do is, as a business owner, is first of all, have a good customer service policy. Um, the you're going to want to make sure that you know what you're promising. And I see businesses sometimes accidentally make promises that they can't keep. That's what happened in yesterday's situation. The business owner who was selling to my client made a promise and then in hindsight realized there's no way we're going to be able to do it for that price. And so be careful of the promises that you make. Second of all, be careful of the work that you do to make sure that you are fulfilling the promises that you are making, because believe it or not, even verbal promises can still be considered contracts. Uh, Look for ways to make your customer as happy as possible when you can't live up to the promises that they're expecting from you. Pardon me. So when you make a promise, if you can't keep it, then talk, communicate, be open, look for win-win situations. Sometimes you see people who have unrealistic expectations and they're never going to be happy. That that is just sadly what happens once in a while. But if you just give them the bird and say shove off, you're going to get negative comments and you might really trigger people's anger. And angry people sometimes do unreasonable things, including making dishonest statements just to hurt you. We don't really want to turn these bad customer experiences into worse customer experience and battles of words. And so look for ways to make things better, to smooth things over to the best of your ability. But otherwise, like I said, haters gonna hate. You can't make everyone happy all of the time, so doing your best is as much as we can ask. And then if someone is lying about you, if they're making false statements, get as much written evidence as you possibly can to show the statements that are made, to show that they're false, and to show that they're causing you harm so that you can retaliate if needed. If a contract is signed between two people in exchange for access to a free service or website, can there be a fee for breaching the contract? And this is a really great question. And why this is so great is because it touches on one of the fundamental truths of contracts. Some people know a little bit about contracts and they know that there has to be an exchange of value. And this is why we sometimes see contracts for $1, because the philosophy is if I'm giving you something of value, you have to give me something back in value. That $1 thing doesn't always do what you think it does, but it does show this point that people generally get, and that a contract does have to be an exchange in value. And so a free service or website can be part of that exchange in value. So a valid contract can exist even though there's no money exchanging. And so in that case, a contract can be valid when it's simply a free service or website. And so if you have a valid contract, it is possible that there can be a fee for breaching the contract. So for example, you might say, I'll tell you what, I'll go cut your grass if you clean up the dog poop while I'm in my yard while I'm gone. Okay, so there's just an exchange of services, no costs. But then, maybe you don't go cut that person's grass, and then the city fines them $100 for not cutting the grass. Well, they were counting on you. They were expecting you to do something. And so that can lead to what we call expectation damages. So that person was harmed $100 because they were expecting you to do something. If you had said, "Hey, I'm not going to cut your grass," then they would have cut it and avoided the $100 fee. And so it can be that there is a fee for breaching the contract, or even a lawsuit for breaching a contract when it seems like there's no money changing hands, because there just has to be a valid contract, which happens when there's an exchange of promises and an exchange of value, and a promise can be valuable. I'll promise to cut your grass. Okay, there's value. Um, if the contract is breached. This question came up 2 times. I can't believe it. 2 times in the last 10 days or so. How can I decide between starting a nonprofit and an LLC? And that seems like an oddly specific question. So that's why I personally put it on the list because it was so unusual to see this question come up twice. And here was the situation in one example. A person wanted to start or continue running an organization. They wanted the liability protection that comes from having an LLC or a corporation, which is what a nonprofit is, formed. But their goal was to provide good to the community, to the world. And in order to do that good thing, they needed to have money coming into the organization. And it is sometimes misunderstood, but nonprofits can charge for services. That's absolutely okay. They can accept donations. They can also charge, but the owners, there's no owners of them. You can't, no one can profit from this. You can pay salaries, and so people can still be compensated, but there's no profits. So I proposed in these situations that came up recently that, first of all, starting a nonprofit is a very complicated process. If you are a small nonprofit that has under $50,000 in annual revenue, you can't, I'm sorry, not revenue, annual income, then you can do the streamlined and simple process, but it can still easily take 6 months or more. And so in each of these cases, I asked the person who wanted to start it, I said, is your goal by starting a nonprofit simply to um, allow people to donate money? Or is your goal to allow people to get tax-free donations or write-offs in order to fund this organization? And if the answer to this question is simply that no one really cares about the write-off, they just want to make sure that they can receive money like donations such, then I'm just going to tell you, you don't need to be a nonprofit. Nonprofits, you have to jump through a bunch of hoops in order to get registered with the IRS in order to offer tax-free donations. But if the people are only like chipping in $20 here and there, it's probably not worth it, because it can easily cost your nonprofit $5,000 or $6,000 per year in legal and tax work that needs to be done. And for many mission focused organizations, that would be all of their operating budget. And so if you want the liability protection, I suggest, and you want to move fast and keep things simple, an LLC can do that. No, you can't give people write-offs so that on their taxes. But for a lot of people, if I got a 1099 for every $20 donation, that would make my taxes too complicated. I wouldn't do it. And so a lot of people, they don't care about that. So you do not need to have a nonprofit just to have a cause or mission focused organization. Now, that said, there is a special kind of business that can have both a profit and a public benefit, and that would be called a public benefit corporation. And this is a type of business that is legally allowed to both have a profit motive, but also divert money from its profits to their public good. And so Patagonia Clothing Company is a classic example. And when I talk about this with people, I use the example of Michael Dell. When Dell was a publicly traded company, when people could buy stock in Dell, Michael Dell had a real problem because some of his investors kept suing him every time he tried to reinvest money back into the business, because corporations have a duty to their shareholders to maximize profits. And in today's world, that's being interpreted slightly differently than it was in the 90s and early 2000s. But at the time, every time Michael Dell diverted some money from shareholders that could have been sent back to shareholders as profit back to the business, he kept getting sued. And so he finally took the business private. He bought all of the shares and took it private so that he could do the right thing. And it was actually a very good move for Dell Computer. But this is something that a lot of people don't understand. If you have a corporation, then you have a duty to do what's best for the shareholders. Well, donating money to nonprofits could arguably not be good for shareholders. They might say, well, no, give me the money. I'm the shareholder. I want the profit. And giving money to the nonprofit organization could be against their interest. And so public benefit corporations are allowed to have two purposes, profit and a public benefit. And so they cannot be sued for serving the nonprofit or public benefit portion of their business in addition to their profit motive. So that is an option. Not all states have PBCs or B corporations, as they're called sometimes. Iowa, Minnesota, California, Oregon, they do. Many states do. I think about 2/3 of states have it. But it is also a bit more complicated. And so typically, if you're just some small community organization, you're going to charge people for a service, and then you're going to also accept donations. And LLC is hard to beat for simplicity and flexibility. And so that's often the way to go. What is a succession plan and how does it work? I ran a big promotion in December to remind business owners that they needed a will. And so this question about a succession plan came up. And the thing is when people ask it, they don't usually use the word succession plan. And so if you can think of a better way to describe this to people, please give me a comment. I would love to know what wording people usually think of. But a succession plan is a way to make sure that your business is able to continue after you're gone. And so if you have a will, then when you die, your personal belongings are distributed to people according to your wishes. That might or might not be what you want to happen with your business. For example, your business might have clients or customers that rely on your business. And you might want to make sure that a key person can continue running the business in your absence. However, your business is a valuable asset, and your estate might wish to sell the business or get the value from the business. And maybe also too, maybe someone in your estate might want to run the business. And here's the tough thing, that might or might not be good for your business. So maybe your brother says, I'll take over for you when you're gone. And you're like, oh boy, based on how you're handling your own finances, that's not a good deal. And so a succession plan is a change to your business operating documents, like your corporate bylaws or your LLC operating agreement. But the succession plan is a change to those documents that clearly spells out what happens when one or more of the owners dies. And so for a single owner business, and this varies from state to state, and it varies a lot, but for a single owner LLC, the common situation is that the business goes into dissolution, which means that it can no longer operate as a business and simply needs to shut down. And then the assets are sold. And again, that might be perfectly fine, but it might not be what's best. And if that's not what you want, then your LLC or corporation needs to have special rules set in place. Attorneys are a classic example. In my state, it is a requirement that attorneys have a succession plan and they have to appoint another attorney. Imagine this. Imagine if I were handling your lawsuit and right in the middle, I died. Then what would happen to you? If I haven't done my duty and having a succession plan, then you're going to be left high and dry. And it's going to be hard no matter what, but without a succession plan, it's going to be even higher. And so I have a duty to my clients that exists even after I'm gone. And many businesses have this, financial, insurance, accountants probably, maybe even medical professionals, but it could be any business that could have this. So succession plan, again, it's just some rules that clearly specify what's going on. Meet with me and we'll talk about it. I'll help you make a succession plan. And you can find more at iowabusinesslawyer.com. All right, this is another conflict-related question. What's the best way to deal with a group of 12 people working together and getting all of the legal sorted out so they can release a product without issue? And I had to edit this question down because this contributor asked for anonymity and they included details that was not going to be anonymous. So first of all, I have to just tell you that there's two unfortunate, bad, unhappy answers to this question. And that is first of all, if you have a group of 12 people working together, but they can't do the legal stuff, then are they really working together? And the answer is no. Maybe they're kind of working together, but if we have 12 people in a authority role in the organization, first of all, that's too many. That's just too many. And second of all, they've got to be actually working together. Okay, that's the first part of the answer that the people aren't going to like. The second part of the answer that people aren't going to like is the best way to solve problems like this is to have good organizational leadership. And that is the only correct answer to this. You need to have a leader who is motivating, inspiring, and encouraging people towards some common purpose. And if you cannot get all of your key people focused on the same goal and the same purpose, then you are failing as a leader. Now, it is possible with a group that big that you will never get consensus. And that's why I say that group is probably too big. But in that case, what you need to do is you need to get a conflict resolution process put in place. And so, for example, we will have people who will start a business, and it might be two owners, and one is 75% and one is 25% owner. And so now we have a problem where the 25% person is usually powerless. And so what we do is when we sit down and form these businesses, we ask hard questions. What are we going to do to resolve conflicts? Your organization with 12 key people needs to do that. And you need to get everyone to agree. When we have a question, if we don't agree, then maybe we're going to vote. And if we get 70% of the votes, then it passes and everyone else has to go along with it. And if they say, well, no, I'm not going to agree to that, then they need to get out because they're not on the same page with you. So you just need to get them out of the organization. 12 people is a hard number of people to manage. And so it's going to require extra strength leadership skills, but also too, you're probably going to have to get to a point of no or low conflict, get everyone together to agree on what they're going to do for future conflicts, get it in writing, get them to sign it, and then that way, when future conflicts happen, then there's a clearly written policy. In this case, this organization is dealing with intellectual property rights. And so one of the things that I would suggest doing is if you are creating, for example, a software product or a book or a video training series or something like that, which are all examples of intellectual property assets that could experience this kind of an issue, then you need to get everyone to assign their intellectual property rights to the organization so that they can't say, the classic example is kids playing at the corner lot playing baseball, and one says, I'm going to take my baseball and go home, and the game is over. And so if they say, yeah, well, you can't have my IP, you need to be able to say, well, you've already done that. You've already given your IP. If you don't want to agree to this and you want to end your future contributions, fine, go ahead and leave. But oops. But they can't take their IP with them. They can't hold the IP hostage. Same person asked another question. Someone on my leadership team is, and that's a serious editing for what they said. Someone on my leadership team is not interested in signing a legal agreement and it's causing an issue. What can I do? First of all, before you have an issue, ideally you need to have a conflict resolution process in place, in writing, signed by everyone. Second of all, you need to exercise leadership ability, and that means getting everyone to the table to talk, have rational conversations. Ideally, when people don't feel heard, they don't agree. And so you want them to feel heard so that their questions are understood, repeat it back to them, make sure that they know that you know what their concerns are. But then ultimately, if they aren't going to sign the legal agreement, then really they're not part of the team. And so you need to get rid of them. You need to get them off the team. And if you have intellectual property rights or something like that, maybe they're an investor and they're going to take their money or their IP and leave. Ideally, you need to resolve that before the conflict happens. What's the difference between releasing a commercial versus a free product? And so I'll just say this, that many products that are free are also commercial. I was talking to a group of software developers recently, and we talked about Flappy Bird. Flappy Bird was one of those games that just out of nowhere became an instant success, and the owner of the app was making tons of money from ad revenue, and it actually caused a lot of stress. If you remember back, the author of that program actually deleted the app because he couldn't handle the stress that came from the overnight publicity that the app received. But was that a free product or was that a commercial product? Well, I would say that was a commercial product. And so, what is a free product? Well, a free product is oftentimes something that has no strings attached. And so, we often see this in open source communities. Open source contributors oftentimes have a deep altruistic role, where as a software developer or a photographer or an artist or a music composer, they've created something and they want to share it with the world. And so they will oftentimes create a license, or they will use like a Creative Commons license to share their creation with the world for free. And oftentimes they simply ask for attribution. And it is actually possible to release something without even requiring attribution. In the US, we have something called public domain. In other countries, they don't have that. And so instead, there is a license called CC0 that lets you essentially give up your right to any future versions of that product. But that's not what this question says. This says, what's the difference between releasing a commercial versus a free product? And so you might say, I have no commercial interest, but I also don't want this to be open source. And so I don't want people to have a commercial, to be able to commercially exploit my creation. That's fine. You're allowed to do that. And so the difference really is you just need to make sure that it is clear what people can and cannot do with the product that you're creating. And that is a legal document called a license. And again, if you want to have something open source, then look at the Apache or FreeBSD license, or maybe the GPL or the GNU public license. If you are talking about a creation that is not exactly software, look at the Creative Commons licenses and see if one of those pre-made agreements says what it is that you feel about your product and what rights you want people to have. You might say none of those work. I want this to be free for non-commercial use. There is a Creative Commons license called the NC, that's November Charlie, the NC license, which is free for non-commercial use. You can do that too. But even if you have a commercial product, you're probably going to have a license that says, here's what you can and cannot do with my product. And so there's really no difference in the releasing part, only in the wording of the license and what permissions you're granting. So again, if you are talking about source code, you might say you can look at the source code. You can use the source code. Here's the rules that are in the license. Or maybe it's not source code. Here's my Creative Commons license. You can use it for this and this, but not that. Or you must quote me or cite me as the author. Whereas the commercial license will have different rules on it. Talk to a lawyer about your specific case so that you can come up with a license scheme that works best for your organization. Do I need an LLC before I purchase my first rental property? And I think I answered that one last week, didn't I? I did. I answered that one 2 weeks ago. So go watch the live stream from before. And so I think that gets me to the end. So don't forget, subscribe. I don't know what platform you're watching me on, LinkedIn, YouTube, Facebook. Great. Thank you for watching. Hit the like button, hit the subscribe or follow button so that you get notified. We do this every 2 weeks on Friday. I would really love to know if the noon hour or the lunchtime hour worked better for you, which is what we did this time, or if you'd liked it to be at the end of the day. We'll make it work, whatever is best for the community. And until then, make sure to submit questions, but I will see you in 2 weeks.